In New York, when one business buys another business assets and liabilities, does it also automatically inherit their personal jurisdiction? To find out, you have to read Lelchuk versus Societe, but it's 13 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Lelchuk versus Societe. The citation for this case is 2024 New York Slip Opinion 02081, published by the New York Court of Appeals on April 18th of 2024. The issue in this case is whether in New York, a non-New York corporation inherits the personal jurisdiction of another company that it acquires without actually merging into that corporation. I'll explain the background that's helpful to understand the concepts in this case. First of all, is the concept of personal jurisdiction. There's two kinds of jurisdiction. There's subject matter jurisdiction, which is not really relevant here, and personal jurisdiction. Personal jurisdiction is whether a specific kind of defendant can be hauled into New York court and required to answer for its acts. It's easy when an actor commits a tort in New York. That's easy. When they're a resident of New York, that's easy. The harder part is when they're not in New York and the tort is not performed in New York. So to that end, Cplr, the Civil Practice Law and Rules, Cplr Section 302 is called the long arm statute. It talks about when a court can acquire personal jurisdiction to cause a defendant to be hailed into court to answer for its acts. And under that section, there are a variety of different grounds to acquire personal jurisdiction over a non-domiciliary defendant, non-domiciliary corporation, and they include where the corporation transacts business in New York, or contracts to supply goods or services in New York, commits a tortious act within New York, or commits a tortious act outside of New York, causing injury to a person or property within New York. Okay, a variety of different grounds. The statute is silent as to whether another entity can inherit personal jurisdiction from a different entity. So that's where this case comes in. The facts of this case are that in 2006, this echoes of certain current events going on recently. In 2006, there was an attack by Hezbollah in Israel, shooting rockets into Israel, harming 21 United States citizens and killing a United States citizen. Those hurt and killed U.S. citizens, including New Yorkers, alleged that the Lebanese Canadian bank financed Hezbollah, was providing finances, was a money laundering operation in favor of Hezbollah, and that the Lebanese Canadian bank, LCB, operated in New York as well. So in 2008, plaintiffs of that case, those injured American citizens, sued LCB Bank, Lebanese Canadian Bank, for their involvement in the Hezbollah attack. In that case, the LCB Bank challenged whether there's personal jurisdiction because they were non-domiciliary that would have been hailed to New York court. That case went all the way up to the New York Court of Appeals, and the New York Court of Appeals said, yes, you are, there is personal jurisdiction over you. Under CPLR 302, you are properly hailed into court. Okay. So that's the law of the case. The law of the case is that LCB Bank has personal jurisdiction in this case. There's sufficient nexus, they held, between LCB Bank and New York due to its contacts and business. It conducted sufficient business in New York that it would be reasonable to assume it could be hailed into a New York court to answer for its actions. But in February of 2011, the United States Treasury Department designated LCB Bank a primary money laundering concern, said that LCB Bank was alleged to have been doing improper things. And as a result, only a few months later, in June, the Société Générale de Banque à Liban bought, basically, LCB Bank couldn't operate business anymore. It had all its liability. So SGBL bought LCB Bank, bought it for $580 million. And importantly, the SGBL Bank bought all assets and liabilities. That's what they said. That's what the agreement said. They bought all assets and liabilities of LCB Bank. That term is really important because in 2019, the plaintiffs now sued SGBL Bank for that same Hezbollah involvement, alleging that LCB committed the tortious acts and that all the liabilities now passed to SGBL Bank, and that therefore SGBL Bank could be held liable in the same way that LCB Bank could have been held liable, based upon that 2011 purchase agreement. At this point, the procedural history is that the defendant bank, SGBL Bank, moves to dismiss and says, we don't know you. We don't do business in New York. No personal jurisdiction. SGBL Bank argued that they didn't inherit LCB Bank's personal jurisdiction claims or personal jurisdiction involvement. They inherited their assets and liabilities. Maybe they're liable for LCB's torts, but find a place to sue me, they say. Federal District Court appreciated the defendant's arguments, dismissed the case for lack of jurisdiction, and it was appealed to the Second Circuit Court of Appeals. They sent it to the Court of Appeals here, and they said, we don't know what the answer is. We don't know how you'd rule. Tell us what the answer is. Here, the Court of Appeals says this is a novel question. It's never been addressed before, whether a successor, a purchaser of a business, whether there's an imputation of the predecessor entity into the successor entity of personal jurisdiction. They go through the general rule. The general rule is that a purchaser of assets is not liable for the seller's torts. But there are 4 exceptions. The 4 exceptions are when a corporation expressly or impliedly assumes a predecessor's tort liability, when there's consolidation or merger of the seller and purchaser, when the purchasing corporation was a mere continuation of the selling corporation, like it's a facade or a sham, or number 4, when the transaction is entered into fraudulently to escape the obligation. They go through those and they go through the policy rationales underlying each, and they say, in this case, the policy considerations favor that the buyer inherits the personal jurisdiction of the seller. And they say that it shouldn't be that a New York plaintiff can't sue a defendant because they buy and sell each other's assets or liabilities. In that case, a sophisticated defendant could sell its assets but not its liabilities, or sell its liabilities but not its personal jurisdiction. They say when you buy assets and liabilities, that includes your personal jurisdiction. So in this case, it's sort of because of that weird law of the case that happened earlier, where LCB Bank was held to have personal jurisdiction in New York, automatically SGBL Bank has personal jurisdiction in New York. And they also say, because of this, sophisticated buyers and sellers should factor that into the purchase price. When you're going to buy all assets and liabilities, consider the fact, and they probably are considering the fact, and they did consider the fact, that the liabilities might require them to appear in a New York court. They should factor that into the purchase price. And that's the case of Lelchuk versus Societe. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.